And we start off with that interview. Israel has decided to dispute the allegations of crimes against humanity directed at Palestinians in Gaza, which are expected to be heard in the coming week at the International Court of Justice in The Hague. To speak more on this, we are now joined by Dr. Kingsley Makhubela, who is the director at RiskRecon. He now joins us live. Dr. Makhubela, good morning. Thank you so much for making time for us. Going through the charter of the ICJ and your interpretation of that application that has been brought by the South African government, you still believe that the case is dead in the water?
Good morning, Audrey. Not necessarily dead in the water. The case has, the presentation of South Africa, if you look at it, is twofold. The strategic thrust of this presentation is really to compel the international community to take some action with respect to the unfolding conflict in Palestine and to stop this really killing of Palestinians and so on. That's too important, and that's very strategic. That's why South Africa has taken this case to the ICJ. South Africa would have as well taken the matter to the Security Council, but given the paralysis in the Security Council, there's nothing that is going to happen. That's one part of it. But the second part of it, which we are daunting task, it's around argument of substantive issues, which may take years actually to investigate and ascertain. But meanwhile, South Africa has taken this position. Let me tell you, in terms of chapter 2, Article 34 of the Charter, it clearly, subsection 1, it clearly states that the court can only hear an argument between states who are actually a signatory, who are part of the United Nations. All members of the United Nations are a signatory also to the statute of the ICJ. So that's one. And so South Africa has taken that because of its concern of what's going on there. But to prove that is going to be a monumental task moving forward. As you know, Aldrin, big powers are likely to join this. In terms of the statute, it allows any country that may think that it will be negatively impacted to be a party to the argument. And I think that will come later on when substantive issues are being debated or argued in the courts.
Yeah. So when we look at that article and the chapter 2, Article 34, you mentioned that it speaks about states. So state-to-state relations and state-to-state disputes, unlike, for instance, with the International Court of, unlike the ICC as an example. But then it goes further to say, when a state which is not a member of the United Nations is party to a case, the court shall fix the amount, which means that the court is willing to hear a case of a country that is not necessarily a member of the United Nations, but it still refers to it as a state. And we know, according to the United Nations at least, they don't recognize Palestine as a state.
All states, as we are talking now, Aldrin, are members of the United Nations. When this charter, when the UN Charter was drafted, mainly in 1945, there was a transition from the League of Nations to the United Nations. So you realize some of the issues were caught in between that transition. That's what happened. That's why they're speaking about states who were not yet signatory to the Convention on the UN. But since all states are part of the UN, that part of it's actually a subsection 3 of Article 35 has fallen off because this is essentially South Africa is standing there as a signatory to this. This is not a convention. This is actually a commitment that all member states have within the United Nations. We will know, even though South Africa recognizes the state of Palestine, but the state of Palestine is not a full-fledged member state of the United Nations. They still enjoy observer status, permanent observer status, I may say, at the United Nations, and that's the only difference.
Could the Israeli government then argue that on the basis that Palestine is not recognized by the United Nations, as a state. Therefore, the ICJ itself does not have jurisdiction to actually hear this matter, even though the matter has been brought by South Africa, which is a member of the United Nations and recognized by the ICJ.
Aldrin, I suspect that's going to be the argument of Israel. They're going to try to find technicalities to throw out this case at the ICJ. And the technicalities will come in many ways. They would argue in terms of the competency of the court, which is really contained in Article in Chapter 2 of the statute of the ICJ. So that's the only basis, because in terms of the substantive issues, South Africa has built a solid case. And I've looked at this. If you look at, for instance, from paragraph 50, I think, to about paragraph 101 of South Africa's presentation, it's based on solid case and evidence and statements made by Israel that really are giving effect to this notion that there's genocide going on in South Africa. That will be very difficult to defend. The only thing that Israel has made a commitment now to go and present, I suspect, will be to try to find technicalities to throw this case out. And I wouldn't be surprised if powerful countries like the United States were to join Israel in the argument that is likely to take place between the 11th and the 12th to throw out this case. And of course, argument will be made that the ICC is dealing with similar issues. Why duplications? And I think those are arguments that Israel is going to try to raise at this hearing. But I think in terms of the substantive issues, Israel will be found wanting.
Israel will be found wanting, but the technicalities that you speak of as well, and we know that the court actually does allow other member states that feel that they are party to the case to actually intervene. And I see that from Clayson Munyela, the head of public diplomacy at DIRCO, earlier on last night, he posted a statement from the OIC, which has welcomed the International Court of Justice suit against Israel over the genocide. And this is, of course, as he points out, these are 57 member states. Does that make a difference at all? And of course, Turkey as well has thrown its weight behind this application.
Already it would have been useful if the Organization of Islamic States have taken this matter themselves to the ICJ. People are fearful of taking this action, given the backing that Israel has from the United States. And I think there will be consequences even for South Africa, because the United States is very much aggrieved. As I said earlier, you may have seen John Kirby from the National Security Council at the White House coming out to say South Africa case is without merit and so on. Because should really the substantive issues be argued, there will be a correlation between the arms that have been sent to Israel by the United States, and the United States may be found to be complacent in terms of this conflict. So the United States is going to stand up. South Africa would have to really have some level of resilience to withstand whatever pressure that may come up from the US. And I think that pressure will come up from the US and the global North to say, why is South Africa acting like this? There will be demonization of South Africa, an attack of South Africa in many international platforms, including blackmails against South Africa. So there will be consequences. The question that I have is South Africa having enough resilience to withstand the fallout from this position.
Yeah, and also thinking about the extent to which, for instance, the United States under the Biden administration is willing to support Israel. For instance, just a couple of days ago, the Biden administration bypassed Congress to sell arms to Israel, which means that they are clearly committed to still being in support of Israel. So what could the possible fallout be then for South Africa in relation to the step that it has taken? Some say it is South Africa has taken the moral high ground, sure. However, though, when it comes to geopolitics, it also plays a crucial role around the messaging that you are sending.
The moral high ground that South Africa has taken would have consequences. We've seen that with the position that South Africa has taken on different issues. Take South Africa's bilateral relations with Iran, and all sorts of sanctions are imposed on South African banks, and South Africa used to buy 30% of its crude oil from Iran. So you would find that kind of reaction because South Africa has taken a decision that really rubs big powers on a different footing. And there will be consequences. But the question is, Aldrin, all of us that will be looking at, is what level of resilience would South Africa have to challenge this and withstand whatever pressure that may come? The position, a lot of people and commentators around the world are applauding South Africa's position. But I can tell you, and I suspect South Africa will stand alone at one stage when it's confronted by big powers. We've been through this as a country in the past. When South Africa took decision on the Ogoni killing in Nigeria, the whole Commonwealth, after President Mandela announced that action and sanction must be imposed against Nigeria, the whole Commonwealth, they stood by and they never intervened. South Africa remained alone and the relations with Nigeria were frozen for quite a long time. So we're going to see the same thing in this respect. Not only the United States, I think the global North will come up hard against South Africa.
Yeah. Seeing what has happened with Uganda, with the AGOA question as well, and it was a huge debate last year as well, and the emphasis from some people that are in support of the stance that South Africa has taken when it comes to the invasion of Russia into Ukraine, was that South Africa remains a strategic country, economically speaking, for the US to access the continent. But when it comes to Uganda, for instance, they've now taken a decision to say that we're going to remove Uganda because of its LGBTQI laws that the country has implemented. Do we see any possibility of the AGOA question coming up yet again, considering that it's up for renewal in 2025?
You will recall there are voices within the U.S. Senate and the U.S. Congress to remove South Africa from AGOA, mainly because of the South Africa stance on a lot of global issues. And I think it's going to strengthen this kind of very right-wing elements within the U.S. Congress on both parties, people who are harboring some extreme right views to get South Africa out because South Africa is acting against the United States security interests, and Israel is seen as a strategic interest for the United States. So we definitely have to expect this kind of fallout. But this kind of fallout in international relations is quite common. If the country it's to be coerced to take certain positions because of the big powers that are really dominating the international space, it will be unfortunate. That's why there's a whole discussion going on about reconfiguration of global power and the distribution of global power to really stop this kind of unipolar world that is really causing serious damage around the global space. So I think this is one thing that South Africa should really stand up for. But Aldrin, we must gear ourselves for a lot of consequences. You're going to find business here that will make a lot of noise like they did with AGOA to say South Africa has done this on Russia. South Africa must be removed from the AGOA list. So you're going to find voices from across. And unfortunately, the U.S. lobbyists are very powerful. They're going to start lobbying here, the international space, the media space, the public opinion, to really push South Africa against going ahead with the substantive argument of the case. Because this is not the beginning and the end of the case from the 11th to the 12th. Yeah. Is the initial stage. The substantive issues may be argued later on.
Yeah, and also some people has also criticized South Africa for taking this particular stance, saying that the matter is already before the ICC. Why do you want the ICJ to also intervene?
You know, because the ICC and the ICJ are two distinct bodies. The ICC, it's a voluntary one. There are members who are not part of the ICC. And that's where I think the Israelis will make an argument to say there's a precedent that even though you are not a signatory to the Rome Statute, the ICC has the jurisdiction to indict such people involved in this. And they're going to try to argue that you can't have two UN bodies arguing on the same matter. Why don't you defer this to the ICC? I think that will be the basis, because in terms of the merits, Aldrin, it will be very difficult for anyone really to dispel what South Africa has put forward.
Yeah. And I see also, looking at the ICJ's charter as well, is that the court can decide not to give an order, but give an opinion and express an opinion. And I wonder what the possibility is of that opinion being expressed, saying that, listen, the ICC is already investigating this matter. Let's allow them to continue investigating this matter, considering also that in 2021, the then prosecutor, that is Fatou Bensouda, announced that the ICC was opening an investigation into the situation in Palestinian authorities. It has taken a while even to bring a case before any individual in Israel, before the Hague. And I wonder if the ICJ then says that actually Israel has a case to answer to, how long that would take, considering, of course, also the Myanmar investigation.
Already, if you look at chapter 3 of the statute of the ICJ, Article 59, really it spells out quite clearly in terms of any findings that are coming out of the ICJ. They are not legally binding. They have no statutory force to really implement them. But it's mainly a good public relation thing in terms of the court. And of course, because the court has no legal binding decisions on member states, it doesn't mean that issues can't be raised. The critical body with legal binding in terms of international law would have been the Security Council, but given the paralysis that is going on at the Security Council, because the US will definitely veto this, what recourse remains for the international community to raise this issue? I think the ICJ remains a valid platform because it carries a moral standing in terms of its decision. It has made pronouncement on a lot of issues. For instance, the argument between Kenya and Somalia around their maritime border. They will make pronouncements, and member states may decide really to adhere to them. Ukraine has gone to the ICJ to present a case against Russia. You can see there are no implementations in terms of whatever outcome came out of that hearing. So, but the moral standing of the ICJ cannot be underestimated. It carries a lot, and the global community is shifting in terms of this conflict is going on. The pendulum is shifting against Israel and the US, and the US cannot keep on ignoring what's going on in Palestine. They would have to act, particularly if the ICJ was to come up with a request for cessation of hostility, because the Security Council failed to do that. That whilst we are investigating the allegation of genocide, there must be a cessation of hostilities, because by the time the matter is finalized in the next few years, there may not be any Palestine as such.
Thank you so much for your time, Dr. Kingsley Makhubela, Director at RiskRecon.